Back to our earlier report now, where we can now bring in the senator representing Edo South Senatorial District, Senator Matthew Urokide. Thank you for joining TVC News at this time. All right, so now that the Federal High Court in Abia State has ruled that Section 84, subsection 12 of the Electoral Act is unconstitutional, and the Senate, which you belong to, has already turned down the president's request on this issue. What happens now?
Well, first, let me thank you for inviting me. The point is this: making law for the good governance of our country, has its own procedure. And the laid down procedure is that the legislature that is charged with the responsibility of making laws of the governance of our land or in our country, has made a law, my electoral law. And that law has passed as a bill, was sent to the president for assent. And the president assented to it. After assent, it only means now it becomes a valid act of the National Assembly. And bringing it back for a recommitter to say a subsection of that law, of that is, clause 84, subsection, 12, was defective, and the National Assembly, just like any other law that was passed, could have been sent back to the National Assembly, for an amendment. Of course, it was sent back to the National Assembly, it came back to the Senate, and the Senate did not see any virtue, in the amendment, and therefore, said that subsection 12 should remain. If that one is done, it only means that the process of making law passed by the legislative and government and assented to by Mr. President, that law process, the lawmaking process, has been completed. To subject a law now to the winds and caprices of the judiciary, for them to say whether it is valid or it's not valid. Yes, in as much as the judiciary has to give explanation or interpretation to our laws that are made, it is not enough to say that a portion of that law, that whole section and subsection, that subsection should be expunged. I don't know. I believe it's actually outside the purview of the judicial arm of government.
And we've seen AGF Malami's apologies for interruption, but we're running out of time. I want to get your reaction on yet another question, because AGF Malami, a senior advocate of Nigeria, has about less than 24 hours after that ruling said that that portion will be expunged, and he has already detailed the printers of the federal government to do the needful. So what are the options left now for the legislature?
Well, for me, I don't know if it's going to be a bad precedent, but I guess it's going to be one. And what the AGF has done, really, it only means that it is putting in danger all existing acts of the National Assembly. The one that does not fit, suit the executive, their liberty to go to court and get that law, vacated or expunged, from our statutes. If this one is allowed to stand, that only means that even laws that are already enacted by the National Assembly could equally be subjected to the same procedure. And it will be very unfortunate. I listened to, and I of course read in the papers, when the AGF said that they were going to gazette the law, the electoral law. And gazetting it means they're going to expunge Section 84.12. And if that one is allowed for a law that has been passed by the National Assembly as a bill, assented to by the Mr. President, became an act, subject it again to another consideration by the judiciary, and then of course the Attorney General, of the Federation saying it's going to expunge it. It only means that all other laws that were passed by the National Assembly can be subject to the same, to the same procedure. Then in which case it's going to bring chaos.
Senator Matthew Urokide, we thank you very much for your contributions on TVC News.